An advantage of having a mediator is that parties can share information somewhat differently. Mediators can be told information that you might not want to tell the other side, but that is going to affect how any kind of reasonable settlement can be structured.
Mr. Mediator, my client's a very proud man. He started this company. And the last thing he would want to tell anybody is that he's got problems. But the truth is, the company is not in the best cash position now. So its credit facilities are stretched. It doesn't have much cash on hand. There is no material payment, no payment that I think the claimant would accept to settle this case that could be paid in a lump sum. My client is simply not financially able to do that. So a settlement would have to be a structured settlement, X dollars over X months to satisfy the settlement obligation. So you can help us, Mr. Mediator, by making it known that the company is not a deep pocket here for the reasons I gave. We're not asking them to take our word for it. So for example, if we proposed a structured settlement and they agreed to that subject to seeing the financials, we would then show the financials.
And you can tell the mediator what the mediator is allowed to share and not allowed to share with the other side. You can ask questions that will help the mediator understand what your client's concerns are and to work with the other side to get information that would at least satisfy a concern that you have.
You can help us out here. We had employees who left the company because of her, and employees who left the company who very well understood her behavior. We think they could be very valuable for us, but we didn't keep track of them. We're not that kind of company, so we don't know where they are, and we don't know what they would say. We can try to find them when the time comes, but we're also interested in knowing whether the claimant has been in touch with these people and whether, unlikely as it may seem, they might be witnesses for her. It would help us a lot if you could get some insight into any of that information. Because, depending upon what it is, it might affect what we're willing to propose. I recognize that they may not be willing to confide that to you, or if they did, that you couldn't confide it to us. But I think that simply by asking them that question, it might help them understand that, they don't have access to such people. On the other hand, if they do, and they're confident, maybe they would authorize you to tell us, because if they have that in hand, they might want to show that to us or indicate in some way to make us move.
Not every lawyer approaching mediation is as strategic as they could be in thinking through how will I gather information that I need in order to resolve the problem. How will I give information without disclosing things that would be unhelpful to disclose or impermissible because my client doesn't want it given. The more we think that through and use the mediator as a conduit to sort of shape what information is given and shape what information we receive, the more we have at our disposal to consider when we're trying to craft a resolution. The whole point is to have as many tools as possible available, and the more tools we have, the better resolution we craft, and the more opportunities and options your client will have available.